Yes. My Lords, I was saying that with regard to the threats of force in issue in this case, that it's implicit that absent some sort of consensual invasion, they involve threats to life and limb of Ukrainian citizens and damage to property. If threats of violence and damage to property had been made by a private party, there is absolutely no question that they would constitute duress. The gist of Russia's position is that threats of violence, when made by one state against another, are treated differently for the purpose of the law of duress. In our submission, that is the wrong way of looking at it. That is a question of justiciability in the sense of suitability, namely the doctrine of foreign act of state. But Russia doesn't want to rely on that anymore, contrary to the approach that it took before Mr. Justice Blair, because it fears either losing that point or, even worse from its perspective, winning that point and its claim being stayed. Instead, what we have for today's purposes is that Russia has tried to reframe the points in rather convoluted ways. For example, as we heard this morning, a threat to a state is not a threat to a person, so it can't constitute physical duress. It's a point made in their reply at paragraph 8 and by Mr. Howard this morning. But first of all, Ukraine is a legal person. Secondly, it is well established that a threat to another can constitute duress to the person, for example, one's employees, see Royal Boskalis. And it's obvious that a threat of invasion involves threats of violence to the citizenry of a country and destruction of property to put that threat into effect. And since we're dealing with a case of duress where the issue is vitiation of true consent and a summary judgment application, it might be useful just to look at the way the threat was perceived. And for that purpose, could we go to Appendix Part 2, Volume 1? The MS number is 9123. And this is the evidence of 9123. This is paragraph 8 in the evidence of Minister Danyuluk. And we can pick it up halfway down. Having dealt with the Russian threats, he says, "I can confirm that it was widely understood amongst the members of the Ukrainian government that these threats were real and that Russia would not hesitate to intervene in Ukraine by different means, including with armed force, if it felt expedient to do so in its own interests. It was well known that threats of the use of force, followed by the actual use of force, had been used by Russia before with regard to other former Soviet bloc nations. There was a pattern. This was understood. Accordingly, these threats were taken extremely seriously by government officials." And then, just to state the obvious, if one goes on to MS 9130 in paragraph 33, the obvious as to what invasion entails, I should draw attention at paragraph 33. He says, draw attention to the factual position that existed after the purported issuing of the Russian Eurobonds. In particular, since February 2014, Russia has unlawfully invaded and occupied sovereign Ukrainian territory, namely the Crimean Peninsula, and used unlawful force in interfering in eastern Ukraine. The effects have been devastating for Ukraine and its people. Thousands of people have been killed, tens of thousands have been injured, and millions have been displaced. The economic effects are also devastating, including the expropriation of state-owned assets and the effect on bilateral trade. Now, with regard to threats to persons other than the victims of the duress, the recipient of the threat, can I just refer you briefly to a decision of Lord Justice Mance, as he then was, in a case called Canalas, which is in the supplemental authorities bundle, and the reference is Sup EF5, it's tab 244. And if the court has that, one sees that it's a a case involving a Lloyd's insurance policy, and the specific issue revolved around a hold-up or robbery limit in the policy. And in the head note, if one looks just above letter F, the assured's account of the loss was as follows. Its managing director, C, was returning from the airport with various members of his family when they were kidnapped. C was told that if he followed the kidnappers' instructions, he would save his family, otherwise he would not see them again. He was instructed to go to the assured's office, as a jeweller's, to empty the safes and to return to a location where the jewellery would be exchanged for his son. He carried out those instructions. And then Lord Justice Mance, paragraph 17 to 18, addressing the duress point. Paragraph 17, he says, Mr. Niche, this is EF, sup EF, page 12. Paragraph 17, second line, Mr. Niche accepted that the only threats of violence communicated to Mr. Canellas, or through him to the respondent's staff, were threats of violence to Mr. Canellas's son, though one should probably add that there were also threats to Mr. Canellas about his wife's and mother's safety. No threats of violence were made against Mr. Canellas, and no threats were made that any violence would be directed against any member of the respondent's staff. Mr. Canellas was forced, as a result of threats of violence directed at his family members, to comply with the thieves' orders to take the emeralds. The respondent's staff were placed under effective duress by virtue of the danger to Mr. Canellas's son, to assist Mr. Canellas so far as necessary to do this, and at any rate not to interfere. But this was not because Mr. Canellas or any such staff were held up or robbed at the premises, or because the particular extra risks to which the clause is addressed ever materialise. And then at paragraph 18, duress can take a variety of forms, many not involving any violence or threats of violence to anyone. The respondent's staff and Mr. Canellas acted under duress in this case, but the duress did not involve any violence or threats of violence in relation to them. It consisted of human and moral pressure, which meant that they had no real option but to act as they did, once they knew of the risk to Mr. Canellas's son and his wife and mother. So, again, we say any dichotomy between a state and its citizenry is a false one in terms of the law of duress. Now, another point taken by Russia is that duress to the person requires the threat to be a threat of action that would be technically unlawful as a matter of English law. That is wrong. In our submission, duress to the person has no requirement of technical unlawfulness. Now, on a basic level, and this was discussed this morning, on a basic level, technical unlawfulness could not literally be required. In Dimskal, the threatened conduct did not take place in England. It took place in Sweden, where it was not unlawful. It only constituted duress by the application of English standards to the impugned conduct. Similarly, and again, this was adverted to this morning, no English court would enforce an English law contract induced by a threat by a foreigner to murder or injure another foreigner abroad, but this would generally not be a crime in English law. Subject to some exceptions, English criminal law is local in effect, and just giving the court a reference without going to it, it's the Privy Council in a case called Somchai, 1991, one appeal case, 225, Lord Griffiths, 244, letters B to C.
Beg your pardon, could you please give me that reference again?
Of course.
1991.
1991, 1 AC, appeal case is 225, and it's in the speech of Lord Griffiths, 244, B to C. Now, as to tort, an English court would plainly not say that a threat can only be duress, including that threat, if it constitutes a tort in English law. And that is clear from Dimskal. I'd like to go to that, if I may. It's Authorities, Bundle 3, tab 20, MS 1299. And the court is familiar with this case, but if we go to 1299 in the electronic version, it's page 169B to D, in hard copy. This is in the speech of Lord Gough, just below letter B. His Lordship says this: it is not to be forgotten that conduct does not have to be tortious to constitute duress for the purpose of English law. This is so even at common law, and still more so if one has regard to the equitable doctrine of undue influence as an extended form of duress. It is by no means difficult to envisage categories of duress or undue influence which might render a contract voidable by English law as the proper law of the contract, but would not do so by the law of some other country where the relevant conduct in fact occurred. So conduct does not have to be tortious to constitute duress for the purpose of English law. And Dimskull makes clear that the law applicable to the legitimacy of pressure is determined by the contractual choice of law rules. It's clear that there is no requirement that to constitute duress, conduct must be actionable as a tort. Action in a foreign jurisdiction may or may not be tortious under the choice of law rules governing torts applied by an English court, but that is irrelevant. Conduct that may not be tortious under the applicable law in tort may nonetheless be illegitimate under English law as the applicable law of the contract and vice versa. So it is plain that actionability in tort is not a relevant test. Now, similarly, this isn't in the bundle, similarly, but in a purely domestic context, Lord Leggatt made the important point in Al Nyan and Kent, this is paragraph 187, that whereas the distinction between lawful and unlawful behaviour may be critical in determining whether the defendant's conduct is actionable in tort, there was no reason why it should be decisive of whether the defendant can retain money or other benefits demanded from a claimant. Now, Al Nyan was before the court in Times Travel. We can supply another copy if necessary, but the Times Travel bundle reference, if your Lordship still have that, is MS 641, Times Travel Authorities tab 18, and paragraph 187 is MS 701 to 702 of the Times Travel bundle. Obviously, the court didn't agree with everything that Lord Justice Leggatt said in Al Nyan, but that point is on all fours with Dimskull, which I've just shown the court. Now, summary judgment application is not the right forum to map the precise boundaries of duress to persons or property, but we do make the following points. First, as a matter of principle, why would economic duress have a lower threshold than duress to persons or property? Now, just going back to Times Travel, if I may, at EF 202, looking at Lord Borough's Common Ground summary, paragraph 136. sub 1, Lord Borough says, lawful act duress, including lawful act economic duress, exists in English law. So the unanimous conclusion of the Supreme Court is that lawful act duress exists, including lawful act economic duress. And we say, why would economic duress have a lower threshold than duress to persons or property? And paragraph 33, which I think we've looked at, Lord Hodge refers to the rationale being different, where the threat is non-commercial in nature. Now, if we keep Times Travel open, the second point we make is again by reference to a common ground paragraph in Lord Borough's. We go to paragraph 88. At page EF 185. And between letters G and H, Lord Burrows says, "It'd be very odd for the civil law of duress not to include threats of lawful acts when the criminal law of blackmail does not do so." Does do so, sorry. And we say it'd be very odd indeed in the context of physical duress. It'd be even odder for the civil law to have a requirement of technical unlawfulness when the criminal defence of duress of circumstances or necessity does not. And for this purpose, could we pick up Crown and Martin? That's in the first supplemental authorities bundle for today, tab 235. It's EF 151, EF 151. And if your lordships have that, you'll see that this is a decision of the Court of Appeal Criminal Division.
We're having difficulty finding it.
I'm sorry, it's EF 151.
Our supplementary bundle only goes up to page 131.
Oh.
It begins at tab 243.
2021 authorities.
It's the 2021 authorities,
Right.
which is the EF 151.
Yes, we have it. It's yes.
Sorry, I don't for the moment.
It's in the same
Yes,
bundle as
it's in the same bundle as Times Travel.
It's just a
The supplemental 2021 authorities.
No, it's not. Well, the 2021 authorities.
I think there were two supplementary bundles from the earlier hearing, but
That's the confusion.
This is the 2021.
Yes,
bundle.
so I will remember to preface it with 2021.
Yes, thank you.
2021 bundle at
Martin, so your lordships will see it's a decision.
it only goes up to 131.
No, it's not that bundle. It's the main.
It's the same travel, the same as the Times Travel.
2021.
So if your lordship goes to the bundle that Times Travel...
I'm working off a different copy of Times Travel. That's the problem.
That explains it.
I'm sorry about this.
It's a bundle with
It's the 2021 authorities.
282 pages in it.
So shall I see if we've got a spare bundle in court?
It's the bundle.
I think that'd be very helpful.
That'd be very helpful. I'm sorry about this.
Certainly, if we can find one. Is it marked?
Don't worry. You can. I'll listen. And I'll read it after.
We will get one to your lordship as soon as we
Don't understand.
are able to.
Well,
If you just give us a moment, Mr. Thank you. We'll see.
Certainly.
Give me a moment. I'll just see if I have anything different. Yeah, so 4. No, beg your pardon, it's not that one. The one above it, the 2021 appeal. Go to page. Go to page 151.
yes. Thank you. Sorry. I'm very sorry to hold up the proceedings.
Just pointing out, this is a decision of the Court of Appeal Criminal Division, and you'll see the head note refers to the defence of necessity in extreme circumstances recognised by English law. Defence arises most commonly as duress, i.e. pressure to put on the accused's will by another's wrongful threats or violence. It can also arise from other objective dangers, threatening the accused or others, amounting to duress of circumstances, and it includes to avoid a threat of death or serious injury. You'll see the judgment of the court is given by Mr. Justice Simon Brown, as he then was, and the offence was driving whilst disqualified. If we go to 152, Appellant appeals against, third line, Appellant appeals against his conviction as of right. You'll see from that paragraph that the judge had held that the offence was an absolute offence, and on that basis, the accused had pleaded guilty. And then just above letter D, we see the facts. The circumstances which the appellant desired to advance by way of defence of necessity was essentially these. His wife has suicidal tendencies. A number of occasions before the day in question, she had attempted to take her own life. Basically, her son was late for work and worried that her son was in danger of losing his job. Appellant's wife was distraught. She was shouting, screaming, banging her head against a wall. More particularly, it said she was threatening suicide unless the appellant drove the boy to work. The defence had a statement from a doctor which expressed the opinion, in view of her mental condition, it's likely that Mrs. Martin would have attempted suicide if her husband did not drive her son to work. Appellant's case on the facts was that he genuinely would suggest reasonably believe that his wife would carry out that threat unless he did as she demanded. Despite his disqualification, he therefore drove the boy, in fact apprehended by the police within a quarter of a mile from the house. And then between F and G, the sole question before this court is whether, on those facts, had the jury accepted them, that they might be true, amounted to, in law, to a defence. If they did, then the appellant was entitled to a trial for the issue before the jury. And it says, as it was, at the end of that paragraph, such a defence was preempted by the ruling, should it have been. In our judgment, the answer is plainly not. And then he identifies, Mr. Justice Simon Brown identifies the principles. First, below letter H, English law does in extreme circumstances recognise a defence of necessity. Most commonly, this defence arises as duress, that is, pressure on the accused's will from the wrongful threats of or violence of another. Equally, however, it can arise from other objective dangers, threatening the accused or others. Arising thus, it's conveniently called duress of circumstances. Secondly, it's a question of an objective assessment, whether the defendant is acting reasonably and proportionately. Thirdly, the issue should be left to the jury. And then finally, if one looks at page 153, EF 153, just above letter C, equally we can see no distinction in principle between various threats of death. It matters not whether the risk of death is by murder or by suicide or indeed by accident. And
what has that got to do with this case?
well, the point is one of principle, that if the criminal law recognises a defence of duress of circumstances where the alleged threat is not unlawful in itself, it'd be bizarre for the civil law not to do so as well, for the purpose of the law
Yeah,
of
but the
duress.
problem is you've got to find some criteria.
Yes.
I mean, my trouble, looking at the pleadings again, I mean, you plead a whole range of actions by the Russian state, some amounting to severe economic pressure, and also some which arguably amount to threats to invade and so on. If this was to go to trial, where does one sort of draw the line?
Well, the core of the Court of Appeal's decision was that they focused on the jus cogens nature of the threat of force. And then everything else, they said, that was the main focus of the decision, and nothing else they thought was liable to be struck out, because the whole of the Russian aggression should be looked at in the round. But the present point that I am on is that there is no requirement of technical unlawfulness to constitute duress for the purposes of physical duress. That's the only point I'm on at the moment. And
I'm finding it very difficult to get my head around a wife threatening to commit suicide and anything that's going on in the relations between Russia and Ukraine.
Well, I'm dealing with quite a narrow point as to whether it's a technical requirement of the law of duress that the action threatened should be unlawful. That's all I'm addressing at this point, not the wider point. I'll come back to the wider points in due course. and one sees that any threat of serious injury suffices, and obviously suicide by the time of this decision was not unlawful as a matter of English law. I appreciate suicide is a million miles away from the facts of this case, but I'm on a much narrower topic. The third point we make is that as a matter of authority, the trustee, in its reply case for this hearing, relied at paragraph 9 on two cases to support the proposition that it's necessary to show that duress to the person or goods is unlawful. And they relied on two cases in their written submissions. One was Barton and Armstrong. I'm not going to turn this up, but it's Authorities 5, tab 44, MS 2220. The court is familiar with this case. It's a paradigm case of duress to the person. Lord Cross referred at page 1112F, MS 2228, to the threats found by the trial judge to have been made in that case as being threats of murder and exerting unlawful pressure. But in our submission, it's not authority for the proposition that only unlawful threats constitute duress. It simply wasn't an issue. And elsewhere, in Barton and Armstrong, the court will be aware that illegitimacy is deliberately used as the touchstone for duress. Not unlawfulness, illegitimacy, and the reference is page 121 of the decision in Barton, MS 2237, which is precisely the same test as in the Universe Sentinel. The next case that Mr. Howard referred to in his reply reply case was the Alev, which is at the 2021 authorities, bundle paragraph 237, EF 204. Now, this is a case showing the overlap of economic duress and duress to goods. And if you have the Alev, I think it's enough just to go to the first holding in the head note. The precise facts don't particularly matter, but if we go to EF 205, the first holding, third of the way down, Mr. Justice Hobhouse, as he then was, says, on the evidence, the agreement clearly fell within the principles of economic duress and duress of goods. Plaintiffs did make a threat which was illegitimate and which they knew to be so. They were under an obligation to carry the goods to Mina Caboose and deliver it there to the defendants. They had no right to refuse to do so or to assert any inconsistent rights over the goods. Defendants neither in law nor in fact entered into the agreement voluntarily, and the defendants had established their right to rely on the defence of duress. The plaintiff's claim failed. And then if we go to page 145, column 2, EF 211, let's start at column 1 under the heading duress. Mr. Justice Hobhouse says, the principle that agreements can be avoided if entered into under duress of goods or economic duress is now well established. And he quotes from Lord Scarman in the Universe Sentinel, and halfway down refers to the two elements being, 1, pressure amounted to compulsion of the will of the victim, and 2, illegitimacy of the pressure exerted. And then 2/3 of the way down, the thread of principle which links the early law of duress, threat to life or limb, with later developments when the law came also to recognise as duress first the threat to property and now the threat to a man's business or trade. And then column 2, first full paragraph, in the present case it's clear that the agreement falls within the principles of economic duress and, for that matter, duress of goods. And then basically we see the head note repeated in the rest of the paragraph, and then he ends the paragraph saying the consent of the defendant was overborne, that there was a coercion of their will, they neither in law nor in fact entered the agreement voluntarily. So what we see here is that Mr. Justice Hobhouse is referring to illegitimacy as the threat, not unlawfulness. On the facts, he says the defendants had no right to act as they did, but again, this is not authority that says only unlawful threats count as duress. If it had said that, it might have been authority which was highly relevant to time's travel. Now, then the trustee, perhaps having recognised the limitation of that authority, cited, and Mr. Howard referred to them this morning, additional textbooks which have been included in the 2021 authorities bundle. The first is Cheshire, Fivefoot and Firmston at tab 240, which is EF 271. And in the last full paragraph on that page, 2 lines down, the rule, it said that the rule here is that the threat must be illegal in the sense that it must be a threat to commit a crime or a tort. And then the title reference is at the following tab, page 276. And at the top of the page, you see duress of the person involves actual or threatened physical violence or unlawful constraint. Footnote 14 refers to a number of cases which I'll try and come back to, time permitting. And it said in the footnote, the violence threatened had to be unlawful. The court sees that. Now, interestingly, those propositions in Tritle and Cheshire and Fivefoot are not reflected, for example, in Chitty, which I'll come back to, Goff and Jones, or Lord Borough's restatements of the law of contract and of the law of unjust enrichment. Rather, the focus in those texts is on threats of violence being illegitimate. And perhaps we can just look at Chitty. There's a brand new edition of Chitty which came out at the end of last month, which we've put in the 2021 Supplemental Authorities bundle. Tab 253, and the electronic reference is EF 106. And sees there at paragraph 10-013, violence or threats. Violence to the person and threats of such violence have long been recognised as illegitimate forms of pressure. The law therefore allows a party to void any promise extorted from him by terror or violence, whether on the part of the person to whom the promise is made or that of his agent. And if you look a few lines down, it says that the editors say at common law, duress consisted of actual or threatened violence or imprisonment. And just, we'll come back to that in a second, just note that if we go to page EF, page 108, under the heading duress of goods, duress to goods is categorised as a threat to destroy or damage property, and that may amount to duress at 10-018. I'll come back.
Unfortunately, the only authority, I think, cited, if you go back a few pages, I mean, there was no authority cited on the passage you took us to, but there is on page 105, if you find footnote 55, the proposition in the text is that threats to the person and threats to commit a crime or tort are always treated as illegitimate. And then, yeah, the only case referred to is this case.
Yes. Indeed. You can tell that this edition of Chitty was written, was probably at the publishers, and then Times Travel came out, because one can see, and we've put in relevant passages which deal later with Times Travel, but you can see the poor editor of this chapter had to incorporate Times Travel quite late in the day. But yes, that's a reference to the Court of Appeal in Times Travel. But going back to page 106, if I may, and if one goes to footnote 60, page 106, there's a reference there to the parallel doctrine in cases concerning marriage. And it is very helpful to look at the parallel doctrine referred to in marriage cases, because if you look at those cases, it is said that the doctrine, particularly of threats of life and limb, that can vitiate marriage, is the same doctrine as the general law of duress. So it is helpful to see the way that's looked at, including by the Court of Appeal. I'll try and do this briefly, but if we go to if we stay in the same bundle, the supplementary authorities bundle, and the marriage cases are well summarised in a case called Re Mayer, which is at EF 61, sup EF 61. And if one looks at the, can I just invite the court to read the head note down to letter G. And if the court has that, the holdings are that there was no reason in logic or principle why the doctrine of duress as applied to the contract of marriage should not apply to a degree of divorce obtained under duress. And he says, just above H, Mr. Justice Bagnall, if the will of the party seeking the decree was overborne by a genuine, reasonably held fear caused by present and continuing danger to life, limb, or liberty arising from external circumstances, which the party was not responsible. And then 2, on the facts, when the wife instituted divorce proceedings, she had a general fear of danger to her liberty and her health, and specific fears of losing her job, etc., and that her will was accordingly overborne by those fears. And she'd established a case based on duress. And then if we look at some of the key paragraphs, we go to EF 68, supplementary EF 68, letter D. The judge says it's well established that where rights and liabilities depend on consent, consent given under duress is no true consent, and the rights and liability be determined as if no consent had been given. Examples abound in the law of contract, and you'll see the reference there to Kaufman and Gerson, which expect to find the principle embedded in any civilized form of jurisprudence. Marriage is a special type of contract because it alters status, and it's plain that the principle, that is of duress, applies to marriage, And he refers to a case called H&H, decision of Mr. Justice Karminski, as he then was, which I'll come back to in a moment, so I won't dwell on the facts of that case there. But if you go on, please, to the following page, just above letter B, it is to be observed that in that case there was no specific threat, but a present and continuous apprehension of danger to life, health, or liberty. And then letter D, there's a reference to a case called Schechter and Schechter. It's a decision of the President of the Family Division. And the judge cites from that below letter E, in order for the impediment of duress to vitiate an otherwise valid marriage, it must, in my judgment, be proved that the will of one of the parties thereto has been overborne by genuine and reasonably held fear caused by the threat of immediate danger to life, limb, or liberty. And then just above G, and the President held that in that case, the test was satisfied. And the judge says, I must confess to having been troubled by the words threat of immediate danger, but having regard to the fact that the President expressly followed H&H, it's not necessary in my judgment that there should be an immediate specific threat. It's sufficient if there is present continuing danger through the apprehended death, injury, or deprivation of liberty, although the apprehended death, injury, or deprivation of liberty may not happen until an unknown future time. And then at page 70, over the page, he holds that the doctrine of duress, since it applies to the contract of marriage, it also applies to the dissolution of marriage. And then this, between D and E, concludes that this court will declare a foreign decree of divorce invalid if the will of the party seeking the decree was overborne by a genuine and reasonably held fear caused by present and continuing danger to life, limb, or liberty arising from external circumstances, etc. And then I add that I think danger to limb means a serious danger to physical or mental health, and that danger must include danger to at least a parent or child of the party. And then finally, at page 80, you'll see he reiterates, just below letter F, to the end of the page, he reiterates the facts we saw in the head note, and comes to the conclusion over the page that the claim of duress was made out. And then just briefly looking at H&H, we go back in the same bundle to EF, sub EF, page 19. That's the H&H case, first instance decision of Mr. Justice Karminski. And looking at the head note at page 19, it says, a woman resident in Hungary was anxious in view of the circumstances then prevailing to leave her native country because of a fear of the danger to her life, liberty and virtue. To obtain a foreign passport, she went through a ceremony of marriage with a French citizen.
Sorry, Mr. Thankey.
Yes.
Page again, please.
I'm sorry. Sub EF, page 19. Does your lordship have that? And the case report begins at the bottom of the page.
Yes, thank you.
Thank you. To obtain a foreign passport, she went through a ceremony of marriage with a French citizen and by agreement separated from him immediately thereafter. Able to escape from her native country, and in due course she presented a petition for nullity, held that her fears were reasonably entertained, were of such a kind as to negative her consent to the marriage, accordingly void. And then page 21, this is interesting because the reasons why the petitioner was anxious to leave Hungary, the final paragraph, are explained. She came from a family engaged in substantial business and of comfortable circumstances, the kind of family who might not be well or sympathetically regarded by a communist government. Talks about her experience when Russian troops occupied Hungary, and then over the page, Petitioner undoubtedly heard many stories of people in a position being taken to prison or concentration camps, believed herself to be in real danger of sharing a similar fate. Asked why she had been so anxious to leave Hungary, she said in her evidence, because the time was so terrible, I was afraid of what was going to happen there. And then we go, please, to page 27. The judge quotes from the judgment of the President, Sir Francis Jeune, in Moss and Moss, a third of the way down, where the President says it's been repeatedly stated that marriage may be declared null on the ground of fraud or duress, and it requires the voluntary consent of the parties being required. And then this, in the case of duress with regard to the marriage contract, as with regard to any other, it is obvious that there is an absence of a consenting will. And then finally at page 269, two-thirds of the way down, the judge finds that on the facts we've seen described, the claim of duress was made out and the marriage was declared void. And just for sake of completeness, if we go back to page 19 in the same bundle behind tab 24, I'm sorry, my fault, page 82, we go forward to page 82, behind tab 251, one sees cases like H&H being approved by the Court of Appeal in the case of Sing and Sing, and court will see this case refers to a Sikh arranged marriage, and that letter G on the hearing of an undefended suit of the wife's petition for nullity on the grounds of duress induced by parental coercion, alternatively incapacity to consummate, the judge held that neither ground was established and dismissed her petition. And the holding, one, that to establish duress as vitiated consent to a marriage, petitioning spouse had to show that his will was overborne by genuine fear induced by threats of immediate danger to his life, limb or liberty. And then if we go, please, to page 87, in the judgment of now Lord Justice Karminski, we see cases that we've seen referred to H&H and Schechter being approved. And the court says it was held in both cases at letter D that in order for the impediment of duress to vitiate an otherwise valid marriage, it must be proved that the will of one of the parties thereto was overborne by genuine and reasonably held fear caused by threat of immediate danger to life, limb or liberty. And then the conclusion was that here there is no suggestion at H of any danger to life, limb or liberty of the wife, and the appeal was dismissed. And then finally, if we just go to Lord Justice McGaw, page 89, between letters G and H, Lord Justice McGaw says, I come to the other recent decision to which Lord Justice Karminski referred, Schechter, decision of the President, and this is said, I do not think that in modern law the rules relating to duress as vitiating the reality of consent to an ostensibly valid contract of marriage differs from those relating to other species of contract. Indeed, I observe that in the well-known textbook Radin on divorce, it's put more strongly, it's said there, with numerous authorities cited in support, that the burden of proof on a party attempting to impeach a marriage on the ground of want of consent is heavier than in the case of impeaching a commercial contract. And what we get from these authorities is that there is no requirement of a specific threat of unlawfulness as a matter of English law. The question is,
But these cases are based on a theory of duress which no longer holds. The reasoning is based on the theory that duress renders a contract invalid, and therefore a contract of marriage is actually void, because the will of one of there's no true consent. The will of one of the contracting parties has been overborne, and on that theory, whether there's duress or not is a question of fact. And that theory was abandoned in Lynch, and the modern theory is the question is whether the conclusion of a contract was materially influenced by illegitimate pressure.
yes, my point is simply when it comes to physical duress, the courts have not required a finding of specific unlawfulness historically.
Well, it weren't focused on the idea of illegitimate pressure at all. I mean, the question really was, how did the person come to consent?
Yes.
And had their, as it's put, had their will been overborne?
The short point is that the focus is not on technical unlawfulness, and it never has been, where threat to life, limb and liberty is concerned. That's the short point. It doesn't really matter whether that concept has been overtaken by events or not, but the focus in where physical duress is concerned is not on technical unlawfulness. It focuses on the nature of the threat.
Can I ask, in terms of the structure of your argument, you see in the textbooks that you've taken us to that a distinction is drawn between lawful act duress and unlawful act duress. And lawful act duress was obviously considered recently in Times Travel. And I'm wondering whether your approach is to say that we're dealing here with another category of lawful act duress that wasn't addressed in Times Travel, or whether you say this is a species of unlawful act duress.
So I'm saying, first of all, the first way your lordship puts it is correct. I do say that that particular problem didn't arise for consideration in Times Travel, and we can rely on unlawfulness in international law for the purposes of the law of duress. The second point I'm dealing with is that there is no technical requirement of unlawfulness where physical duress is concerned. So that Times Travel doesn't preclude our case, doesn't do violence to the way that Ukraine puts its defence of duress. The test is illegitimacy, and the threat of violence in itself is illegitimate for the purposes of physical duress. And the court doesn't focus on whether that violence is technically lawful or unlawful. Does that answer your question? Now, if we go back to Tritle, it's interesting that the trustee didn't seek to put the supporting authorities relied on by Tritle or Cheshire and 5 Foot before the court, and we have spent some very boring hours looking at the cases, but I'll try and summarise them because they're some antiquity. But if we start with Cheshire and 5 Foot in the supplemental, the 2021 authorities bundle at EF 271, I took the court to a moment ago. And if you have that, you see that the Cheshire and 5 Foot reference, where it says the rule here is that the threat must be illegal in the sense that it must be a threat to commit a crime or a tort, footnote 276, the only case cited at footnote 276 is a contra authority, Ware and de Freville. And we've looked at that. I'm not going to waste the court's time by referring to it. It is a conspiracy and libel case and has no relevance to the issues in this case. So that doesn't advance matters. And then if we go to Trital, page 276, I showed your lordship's footnote 14, where it said the violence threatened had to be unlawful. And I've said you'll see the case is referred to. Interesting, one of the cases is Halpin and Halpin. And perhaps we could just take a quick look at that. It's in the supplemental to 2021 authorities bundle at tab 247. The reference is EF32. If the court has that, you see it's a dispute between four brothers under the will of their, relating to the will of their late father. And then you'll see that as the parties, about 5-6 lines down, as the parties were Orthodox Jews, it was agreed that the dispute should be resolved by arbitration, conducted by an ad hoc Beth Din consisting of 3 rabbis. And then 2/3 of the way down, one sees that a compromise agreement was reached. And then at the bottom, on the left-hand column, 3 of the brothers argued that the compromise agreement was ineffective because, and then we can just go to Roman 2:5 lines down, one of the reasons relied on is that the compromise agreement was procured by duress, and that one of the arbitrators had insisted that in the absence of a compromise, the 3 brothers were required to make an oath which an observant Jew would not in practice be willing to make, or to pay a forfeit. And you see it holding one, the settlement agreement was governed by English law. And then if we go on to page 46, using EF numbers, and could I just invite the court to skim read paragraphs 85, 86 and 87. I'm grateful. So that's one of the cases relied on in the Trital footnote, and it doesn't really support the proposition in support of which it's relied on. The deputy judge, Christopher Clark QC, as he then was, considered the duress issue to be arguable. It's an odd case for Trital to cite here. in support of that proposition, because plainly the conduct would not have been a breach of any English municipal law. Now, just for completeness, the court, this case, after a further hearing in front of another deputy judge, went to the Court of Appeal, in which my Lord Justice Carnwath, or Lord Justice Carnwath as he then was in the Court of Appeal, but it didn't go on this particular issue. It went on another matter.
I'm glad I didn't have any recollection of it.
No, it doesn't surprise me. So then, looking at the other cases in the Triton footnote in support of this proposition, they really don't advance matters. In the same supplemental bundle, at EF3, we put in the case of Biffin and Bignell. That was a threat to confine a wife in a lunatic asylum, and it doesn't support the proposition. Chief Baron Pollock and Baron Wilde held that there was simply no duress in the case. And Baron Bramwell refers to the threat not being unlawful, but he goes on to say, in any event, it didn't constitute duress. So that doesn't advance matters. Then Cumming and Ince, which is same bundle EF15. Yet again, we have a threat of confinement to a lunatic asylum. The primary issue was the validity of consent to the contract entered into if the plaintiff was a lunatic. If she was of sound mind, the threat to confine her to an asylum was held arguably to constitute duress. But in that case, there was no consideration of whether the prosecution of the commission of lunacy itself was lawful or unlawful. And then Smith and Montiel at EF92. That simply supports the proposition that the threat of confinement to a debtor's provision, the threat of confinement to a debtor's prison, it was held that the threat of lawful detention could not amount to duress. I'll come back to that in a second. And then Latter and Bradell, the other case referred to in the footnote at EF54. And we put in the first instance decision and the Court of Appeal decision. And if I can summarise, one sees the first instance report. The central issue involved allegations of assault and coercion of a servant subjected to a medical examination. And the key issue was whether there could be any assault or coercion by reference to the issue of consent to the medical examination. And interestingly, if one goes, there are two judgments here, but if one goes to Mr. Justice Lindley at page 57, left-hand column, five lines down, the plaintiff had it entirely in her own power physically to comply or not to comply with her mistress's orders. There was no evidence whatever to show that anything improper or illegal was threatened to be done if she had not complied. So one sees the reference to improper or illegal, which does not fit with any requirement of technical unlawfulness for what it's worth. And the Court of Appeal at the next tab, beginning at 59, all three judges basically agree with Mr. Justice Lindley.
It's interesting that in the Biffen case and the latter case, Baron Bramwell in one and Mr. Justice Lindley in the other, they were both the trial judges.
Indeed,
and then sat in the Court of Appeal, and Baron Bramwell decided that he had misdirected the jury.
Indeed. It made me laugh when I read that, and I'm afraid my ignorance of how this worked when you can sit and appeal on yourself
Yes.
is... Yes, so Baron Bramwell says, I have come to the conclusion that I misdirected the jury.
Yes.
But in our submission, at the end of the day, these old cases are generally about detention or confinement, where the legality of the process may determine whether the threat of detention could constitute duress. They say nothing about any general requirement of technical unlawfulness in the case of duress to the person, especially threats of violence, or duress to property. And ultimately, my lords, the old cases don't assist in ascertaining the minimum criteria for duress, and they sit uneasily with Dimskull, which I showed you a moment ago, and the more modern marriage cases. And one can test the trustee's case by some examples where it must be obvious that the courts would not require the threat to be unlawful in itself. And first of all, and this is obvious from what we've said already, but I'd venture to suggest that no English court would enforce a contract induced by a threat to commit suicide, even though suicide is not in itself unlawful, leaving aside the criminal cases. Also, we say no English court would enforce a contract against Party B induced by the threat to destroy any property, even if the property belonged to Party A making the threat, and he was, as a matter of law, entitled to do what he threatened. Now, leaving aside modern cases, modern law on animal cruelty, would an English court enforce a contract where Party A had threatened to kill his own domestic pet unless B signed the contract? We suggest not. But provided you do it humanely, it is not illegal in England to kill your own domestic pet. Or would a court enforce a contract induced by the threat to destroy cherished property which Party B might stand to inherit by Party A to whom the property presently belonged? Again, we suggest not. In our submission, these types of threats would be regarded as illegitimate means of persuasion, vitiating true consent, even though they involve no technically unlawful threat. Now, during the first leg of this hearing, Mr. Howard accepted that if the Eurobond transaction was induced by a threat to kill the Ukrainian finance minister, that would be duress, and Mr. Howard called that my favourite example. And what Mr. Howard invites the court to say is that a threat to the use of force on a much larger scale would not be duress at all, because it would relate to matters of high policy, war and peace, etc. And in our submission, this shows the fallacy at the heart of Russia's argument. And really, it's the problem with trying to shoehorn everything into domestic foothold territory to assert that there is no duress. And that leads the trustee and Russia into error. It confuses issues of justiciability under the Foreign Act of State principle in the sense of suitability and relevance. Some issues may be unsuitable for determination by the English courts, but that goes to suitability pursuant to the application of the Foreign Act of State principle, not to the existence of duress in English law in terms of coercion of the will. A threat to invade can be just as much a coercion of the will as a threat to kill the Ukrainian finance minister, but some will be more amenable, some threats will be more amenable to the application of the Foreign Act of State principle. And it wouldn't make a difference in terms of the vitiation of consent if the order were given by President Putin. It might make the court more reluctant to adjudicate on the issue because the decision might be thought to be more political, see Butte's gas. But it doesn't affect the nature of the duress or the vitiation of true consent. And we gave other examples in our written case during the first leg of this hearing. The Ukrainian finance minister is tortured by Russian special forces until he approves the Eurobond issue, or the Ukrainian finance minister's children are held hostage by Russian forces under threat of torture or execution until the Eurobond issue is approved. Or thirdly, artillery and airstrikes are launched on Ukrainian towns by Russia until the finance minister approves the Eurobond issue. Now, the last example in particular might fall within the scope of a no-go area, as in Butte's. But as a matter of principle, the decision of the finance minister is subject to coercion in each example. Just as in the example of the mere, I quote, inverted commas, mere threat to assassinate the finance minister, which Mr. Howard accepted would be duress. Each example is capable of amounting to duress. And the heavy lifting here as to whether the English court will venture into these areas is done by the Foreign Act of State principle, not by redefining duress to exclude certain actions by states. And the Foreign Act of State principle is plainly a more suitable tool. It recognises that foreign states should not always be held to the same standards as commercial counterparties. That's what the Court of Appeal did below. It requires a sophisticated analysis of the nature of the transaction and the requirements of English, critically the requirements of English public policy. And where the application of the doctrine prevents a fair trial, it leads to a claim being stayed rather than succeeding automatically. And the Foreign Act of State principle reflects fundamental principles of English public policy. Now, Russia repeatedly says that this is an ordinary commercial contract, but which commercial counterparty would be able to enforce a contract under threat of death, injury, or destruction? Imagine if VTB, let's say a Russian band, let's take VTB as an example, threatened to use hired mercenaries to operate in Ukrainian territory unless the finance minister approved the Eurobond issue for acquisition by VTB. The fact that VTB is threatening it rather than the Russian state threatening the use of its regular armed forces does not affect whether the conduct is capable of amounting to duress. Each act amounts to coercion of the will of the finance minister. What the difference in the identity of party A might affect is the application by the courts of the Foreign Act of State principle, not the vitiation of true consent. In summary, we say that the threat of violence renders the contract liable to be set aside. Point one. Secondly, the identity of the threatening party goes to the issue of justiciability, not the vitiation of consent. And thirdly, one does not need to establish a crime or a tort as a matter of English law to establish duress. And that would plainly be inconsistent, any such requirement, with the passage from Lord Gough's speech in Dinskar, which I showed your lordships a moment ago. And we say that the ramifications, if Mr. Howard's approach is correct, are quite stark. It involves granting effective immunity to states where English law contracts are affected through the threat of force. And that would be, we say, a very unattractive outcome for English law, provide a powerful incentive to rogue states to give effect to their threats using the vehicle of English law contracts, secure in the knowledge that the threats will be ignored by the law of duress, and the English court will have to enforce the agreement forcibly obtained by pressure. And the fact that, so far as Russia's neighbours are concerned, these are not academic fears, is underlined by Minister Danieluk's evidence, which I referred to. A few words, please, if I may, about public policy.
Could I just, before you go to that,
My Lord, yes.
I'm still struggling a bit with the emphasis you put on threats of violence. I mean, if we look at the pleadings, the defence at MS 8823, basically what you're pleading is a sort of campaign of economic and political challenge, really, which makes it, puts Ukraine in an impossible
Well, that's one of the
threats of violence before the entry into the trustee in December 2013. I'm not sure where they are. Where are the threats of violence?
I can show you. I mean, it might be. The allegation is the threat of the use of force.
Yeah, well, can you just point me to the one?
I think it was, you summarised it in statement of facts and issues in paragraph 6, I think.
Yes.
8311.
Indeed.
Yes, I've seen that. I wanted to see the pleading.
Yes.
That is the agreed position of the parties, that there were these threats in 2013.
Yep. So it's MS 8834, my lord.
Yes.
Paragraph 21 of the defence. 21.1.1, threat of the use of force.
Yes, but where does one find the allegation of threats of the use of force?
So the threats, I mean, this is not in issue, but threats are, it's probably easiest, if I may, to show you the judgment of Mr. Justice Blair, where he summarises them, if I may.
But I'd have thought you'd be, I mean, presumably they would be in the pleading them there.
But they are. I can show you that too, if you prefer it.
I mean, the point I'm making, I mean, there's general suggestions about violence, but as far as I can see, the burden of the pleading is about economic.
No, that's not true. The core threat is a threat of the use of force, and that is the way the Court of Appeal approached it, my Lord.
Well, show me the pleading.
Yes, it's 20.7, if I can give you some examples, 20.7.2, MS 8833.
What could no longer guarantee Ukraine's status as a state.
Yeah, and could possibly intervene if pro-Russian regions of the country appeal directly to Moscow.
And
20.8, partitioning.
Sorry, and if you could remind us who Mr. Glaziev was.
He's an advisor to President Putin. But none of this is an issue. It's common ground that the
I understand that. I just want to know what is being alleged.
partitioning of Ukraine at
Because if we're
20.8.
trying to redefine the law of duress, I'd like to know what it actually encompasses.
Well, I'm not trying to redefine the law of duress, but the partitioning of Ukraine at 20.8.
Well, paragraph 17 at 8829 has abundance of fact as well.
Yes, indeed.
The steps included the unlawful trade measures, as well as threats regarding the security of Ukraine's status as a sovereign
Sorry, which one is
state,
there?
including its territorial integrity.
Sorry?
Paragraph 17, 8829. I think you referred us also to the minister's statement where he said that the government took the threat to Ukraine's territorial integrity
Indeed.
very seriously.
Indeed. And 20.8, 20.9, my lord, just to complete the picture. Public policy. We say, my Lord...
Could you just give us the reference to Mr. Justice Blair?
Yes.
You were going to take us there, but if you could just have...
I was.
8746, I think, seems to be helpful.
Yes.
MS 8746.
Yes.
Paragraph 181.
Yes. So,
Thank you.
yes, thank you. So the references to Mr. Justice Blair that I was going to take court to, I took the court to 308, subparagraphs 1 to 4. And then 181 to 185 at MS 8746, which my Lord Kitchen referred to. And then the other paragraphs, which are probably worth looking at, are 191 to 222 for volume 2, 249 to 252, 272 and 295, subparagraphs Little Roman 1 and Little Roman 2 were the paragraphs I was going to take the court to. The core ones on threat of force are the first two.
As far as these threats are concerned, do I understand it to be your submission that one can't separate one from another and one has to look at it as a concerted...
Yes, and can I just show, my Lord, the way the Court of Appeal dealt with it, because that's effectively exactly what they said. So if one goes, please, to 165, 8673, MS 8673. Paragraph 165, we looked at 164, 165, it's common ground that the use of force by one state against another, also the threat of the use of force by one state against another are in violation of the general norm of international law, the state of jus cogens, and then reference to Article 2.4, and then 166, Lord Sales refers to Russia's obligations under the Budapest Memorandum and the 1997 treaty, and then at the end of 166, further threats allegedly made by Russia to impose unlawful trading restrictions to damage Ukraine's economy. And then 167, I think, addresses my Lord Kitchen's point more specifically, is that the focus at the hearing, the Court of Appeal says, it was on the jus cogens, the strongest aspect of Ukraine's case in relation to the alleged breach of jus cogens by Russia as a threat of force. So the main focus has been on that. In relation to these further matters, it suffices to say, if Ukraine establishes that it's an arguable defence of duress by reference to alleged breach of jus cogens, as we consider it does, for the reasons set out below, there's no part of Ukraine's case in relation to those further matters which we are persuaded should be struck out as being unarguable, either on the facts of the law. On the contrary, in our judgment, desirable that these further matters pleaded by Ukraine should be an issue for exploration at trial, with the benefit of the full findings of fact, both as independent aspects of the defence of duress and also as relevant factual background to allow the whole pattern of alleged threatening behaviour by Russia to be assessed in full context.
And your submission is that that would apply whichever way you put your case?
Yes, indeed.
It is as equally applicable to the way you've been elaborating your submissions to us?
Indeed, my Lord, yes.
During the course of the day.
I do say that.
And the pleadings you've taken us to are really directed to, are alleging threats designed to deter Ukraine from entering into the association agreement. And is it a matter of causation as to whether those threats also materially influenced Ukraine's decision to enter into the loan agreement.
Yes, and that's the conclusion that Mr. Justice Blair came to that was arguable.
This is the carrot and stick point.
It's partly the carrot and stick point, but the key aspect to that is that what Russian threats and aggression did was to deny, at a time where Ukraine's public finances were in dire straits, was that effectively Russian pressure denied Ukraine access to the capital markets. And so it's partly carrot and stick, but it's not a particularly attractive carrot. Because what Ukraine wanted, and this was a fundamental aspect of Ukrainian policy, and you'll see this in the references to the judgment of Mr. Justice Blair I referred to, since 1991, the breakup of the Soviet Union, fundamental aspect of Ukrainian policy was to enter into a closer association with the EU, culminating in membership of the EU, for which the association agreement was a stepping stone. And effectively, Russian pressure was designed to divert Ukraine from doing that. It denied us access to capital markets, the capital markets, and we were left with no effective choice but to accept funds from Russia. So it is carrot and stick, but from a Ukrainian point of view, given Ukrainian policy since the end of the Soviet Union, it wasn't a very attractive carrot.
I mean, the causation issue isn't before us today.
No, it's not an issue.
But am I right in thinking that the offer of the finance was made at the same time as the pressure to withdraw from the association agreement?
Yes, and this is part of the problem with being taken slightly out of course, but this is something which Mr. Justice Blair refers to in tandem in his summary of our case. At the same meeting where we agreed that we would not enter into the EU association agreement, we also agreed, interestingly, at the same agreement, they agreed to withdraw the trade measures when we agreed we wouldn't enter into the EU association agreement, and they also agreed to the package of financing. It's all part and parcel of the same occasion, in fact.
May I ask another question?
Certainly.
It may be this is a question of causation, but how serious does the threat on your case? How serious does the threat of physical violence have to be to permit you to rely upon the defence in relation to all of these transactions?
Well, it also has to be a credible threat. I think it is ultimately a matter of causation, which isn't before the court as to whether we were left with a reasonable alternative or not. But I think, looking at Barton and Armstrong, if you're talking about physical duress, the test of causation is lower than with other forms of duress, and that's something something that Lord Burrows adverts to in his judgment.
No,
it just has to be a cause rather than being left with no reasonable alternative, etc. I think it's a lower test for physical duress.
A cause is
a
the way
cause.
That's your submission.
That's what Barton and Armstrong holds.
I think you were about to turn to public policy.
Yes. We say that the trustee's stance on physical duress is impossible to reconcile with the Court of Appeal decision in Royal Boscalis. In oral argument in round one, Mr. Howard simply said that Royal Boscalis was a plain vanilla case involving duress to persons and goods, and he said it has absolutely nothing to do with international law. Now it's said that Royal Boscalis is a second limb times travel case, said in their reply submissions at paragraph 2024. And we say that is an extravagant submission. And if we just turn up Royal Boscalis, it's in Authorities, Bundle 3. MS 1149. So in Royal Boscalis, in order to secure the release and repatriation of its employees and to prevent them being used as human shields, i.e. hostages, the claimant paid large sums into bank accounts in Switzerland and waived contractual rights. And if you look at the head note in the E&F, in order to secure the demobilisation of the fleet and the repatriation of their employees, the plaintiffs negotiated and signed a finalisation agreement with the Iraqi authorities, pursuant to which the plaintiffs paid large sums into bank accounts in Switzerland and Austria and waived all further claims under the dredging contract. Now, is the trustee saying that but for the waiver, the court would have held the contract to be enforceable? And in our submission, obviously, that cannot be right. If we go to 689, 1164, MS 1164, see Lord Justice Stuart Smith, letter C, there was no dispute that the finalisation of the contract was obtained by duress, and duress of the most extreme kind. Not only was their entire fleet seized, but the Iraqis were threatening to use the European employees of the joint venture as part of the human shield policy, say nothing of the fate of the non-European employees. Mr. Akins did not seriously dispute as a matter of English public policy. An English court would not give effect to the finalisation agreement and the waiver of claims at the behest of the Iraqis. So it's both aspects. And then at E, I think that any civilised tribunal would refuse to give effect to it. In my opinion, this affords a complete answer to the plaintiff's claim on the basis, etc. And then it's at 1205 in Lord Justice Phillips' judgment. Just above letter C, the basic facts as to duress are not an issue. However much the effect of Kaufmann and Gerson may have been narrowed by Dimskal, I don't consider that there is any chance that under English law, the duress to persons that was imposed in this case would be considered a matter for the approach adopted in the latter case rather than the former. The threat to use a large number of personnel as human shields was about as cogent and unconscionable a form of duress as one can imagine. There's no hint that this is only because of the forced waiver of existing contractual rights. It's because of the egregious physical duress to take hostages, euphemistically referred to as Iraq's human shield policy. And it's telling that the party applying the pressure in this case was the state of Iraq. And it could equally not be suggested that it makes any difference that the victim of the threat in our case is a state or its citizens rather than a company, as in Royal Boscalis. And if you've still got Royal Boscalis open, at 729 E to G, MS 1204, you'll see, actually, if we go back to 1202, just above letter H, you'll see there's an extensive citation beginning there of Dimskal shipping, which goes through to page 1204. And then just below letter E, Lord Gough recognises the potential applicability in the context of a case of duress of the primacy over foreign law of the distinctive policy of English law. And in letter G, he goes on to deal with Dimskal, and the duress there was of a different kind to that involved in Kaufmann and Gerson. And he says in relation to Boscalis, the range of duress of that type were to be rendered acceptable to the English court by virtue of the effect of a choice of law clause induced by the same duress, or because the law of the country over which the contract induced by duress had the closest connection regarded the duress as acceptable. conclusion is that there remains a class of duress so unconscionable that it calls the English court, as a matter of public policy, to override the proper law of the contract. And we say that this is even more so where the contract is an English law contract and Russia has invoked the jurisdiction of the English courts to enforce it. And that was a point made with some force by the Court of Appeal in this case below. It's all a question of English law. And the relevance of international law in this particular context is important principles of international law are also reflected in English public policy. And notably in Royal Biscalis, Iraq was undoubtedly acting in the course of war in seeking to maintain its annexation of Kuwait. And Biscalis recognises that duress can be so egregious that it offends public policy. And on the facts of that case, it was a threat of the use of force by the Iraqi state. Secondly, Kuwait Airways begins at MS 589. I won't turn to it in interest of time, but it recognises that public international law can inform the scope of English public policy. And that includes most fundamentally the UN Charter. And just to give your Lordship some references, it's paragraphs 22 to 29 of Lord Nichols, 114 to 115 of Lord Stayne, and 145 of Lord Hope. I'm nearing the end of my time, so can I just say, in relation to the application of times travel category 2 to our case, if that's necessary, I refer to paragraphs 8 to 18 of our case for today, which is in the 2021 call volume, beginning at EF 31. And in terms of the reprehensible means used by Russia, we say that it's hard to conceive of a more reprehensible form of conduct than making threats contrary to Article 2.4 of the UN Charter, one of the foundational principles of the United Nations. The article by Sir Michael Wood, as my Lord Lloyd-Jones mentioned, it doesn't ultimately matter whether this is jus cogens or not, but we've put forward an extract from a book called, in fact, The Threat of Force in International Law by Sturchler from the University of Basel, who says that no distinction should be drawn between the threat and the use of force in Article 2.4 for the purposes of jus cogens, that both are equally jus cogens. And the reference to that is that in the supplemental 2021 authorities bundle, tab 254 EF 130. And in the Nicaragua case...
You're going to have to come to a close very soon, Mr.
I am.
Right, fine.
I was just going to say the Nicaragua case, paragraph 227, the ICJ drew no distinction as a matter of legality between the threat of the use of force and the actual use of force, either in its analysis of customary international law or jus cogens. Paragraphs 187 to 190 of Nicaragua and paragraph 227 of the Nicaragua decision. And finally, my lords, in terms of the Court of Appeal's approach and the reference to moral or social unacceptability in paragraph 157, if that were the minimum threshold, it mattered little at that stage, whether the nature of the duress was physical or economic. That assumption has obviously been superseded by times travel in the case of economic duress, but in our submission that does not affect the outcome, either because the core allegation is of duress, is a physical duress, and the court has our submissions on that, or because we come within times travel category 2. And my lords, unless I can assist you further, those are my submissions.
Thank you very much, Mr. Sankey. Yes, Mr. Howard.
My Lords, I would imagine that it has become plain in the course of this hearing that despite the eloquence of Mr. Thankey's advocacy, there has actually been a fundamental shift in this case. Not least, one can see that from the cases that have been cited to you, which haven't even been, many of which aren't even referred to in the 3 written cases that have been put forward. Now, why? I'm not simply complaining about authorities coming late. The question one has to ask, well, how is it that the cases which are now being put, as it were, front and centre of the argument have only come forward in the last couple of days and been addressed orally? Now, the point about this, the reason this has come, is that there is the truth is that Ukraine has not been running a case of duress to persons or duress to goods. That isn't the case that's been run to date. And the passage that you were taken to in Mr. Justice Blair's judgment, I'll come to that in a moment, wasn't saying this is a case where Ukraine is arguing that we are within duress to goods. Now, or duress to persons. Now, the thing that's slightly obscure is to actually try and understand, well, what actually is it Ukraine is saying? Now, as I understand it, it is actually common ground that for duress, whatever the form of duress, the threat has to be either unlawful or illegitimate. As I understand Mr. Thankey's submissions, what he then says is, well, if I can categorize the threat as one of threat to the person, or violence to the person, that necessarily is illegitimate, and therefore that will suffice. Now, that is a very, very broad submission. We suggest it is obviously wrong. For instance, one can think of lots of situations where there can be what are threats of violence, which are lawful threats of violence, and which in our submission would not amount to duress within our law. For instance, the classic one is self-defense. If you were threatening somebody that you were going to retaliate to an act of violence that they had committed towards you, that would be legitimate, lawful conduct. Now, that's just to set things in context. Now, the passage that you were shown in Mr. Justice Blair's judgment, if we could just go to that, which Mr. Thankey started with, saying he was surprised at what we were saying because things have been, as it were, decided and not appealed. If we go to MS 8767, what in the passage on which reliance was placed at 3082, what you'll see is Mr. Justice Blair wasn't saying this was the case, that they were relying on a case of violence to person. What he said was, in English law, violence to a person or threats of such violence have long been recognised as a paradigm form of duress. If the same approach is applied to Ukraine's defence, in other words, that there is a threat, then the defence is strong. What he's saying is, on the facts, the threats, which we accepted that they were entitled to say there was a threat to invade, as one can see, well, you can see the nature of what is said. But all he's saying here is that he's not dealing with the question of whether or not, as a matter of law, any of this amounts to a threat for the purposes of the law of duress, and he's not characterizing it. He's simply saying if these facts are established, they would have a strong case, and we haven't at this stage sought to dispute the facts. Now, my Lord, the really fundamental point, sorry, just to pick up the other reference in this bundle at 8678, which was paragraph 164 of the Court of Appeal's judgment, all that is saying...
Sorry.
8678, I think it is. No, sorry, I've given you a false reference. It's paragraph 164. It's 8672 and 3. All that paragraph again was saying was, it's simply saying that the factual allegations, if made out, would prove their case, but it's not dealing with the characterization of the threats. And you can see all it's saying is there was an alleged threat to use force against Ukraine and its territorial integrity. Now, the fundamental issue in the appeal, in our submission, concerns the scope of times travel, or the fundamental issue for today. Now, what is being said to your lordship is, as I understand it, that times travel should be confined and it can't apply to a case such as this, where you have dealings between states, and it's confined to economic duress. Now, there are a number of difficulties with that. The first is this. The first category that Lord Hodge deals with in his paragraph 4 at EF page 158, that is to say, a defendant using his knowledge of criminal activity by the claimant or a member of the claimant's close family to obtain a personal benefit from the claimant by the express or implicit threat to report the crime, that is a non-commercial threat. It's not a threat relating to, I don't want you to contract with somebody else, you must contract with me. It is a classic non-economic threat. Now, and indeed, that is, I think, the point that Lord Burrows made when he was reviewing the cases. So 3 of the 5 cases which have recognised duress and are being discussed are cases which are not concerned with economic duress. Now, what is actually common ground between the parties, or it was in the written cases as originally exchanged, is that for the purposes of duress, what you are concerned with is an illegitimate threat. Now, the question is, what guidance do we get in the English cases as to what is regarded as illegitimate? Now, the answer to that is actually straightforward now. Something is illegitimate if what you're threatening is unlawful conduct, or conduct which would be unlawful as a matter of English law. But once you come outside unlawful conduct, you're then left with lawful conduct, which only in very confined circumstances can be treated as illegitimate. And so if you take a position between two commercial entities in this country, what Times Travel is saying, well, you can have all sorts of negotiation going on. Some of it the law will regard as disreputable, some of it as morally reprehensible, but if it's lawful conduct, in other words, you're not blackmailing, you're not committing some tort, then Times Travel is saying we look at things in a very confined way. Now, in our submission, there's absolutely no reason why one applies some different approach just because you've got states. I mean, if you think about it in this way, you have two commercial entities. One has the stronger bargaining position. That entity seeks to take advantage of the weak position of the other. This is the sort of stuff of everyday commerce. Maybe saying, I'm going to undercut your prices, assume it's not acting in an anti-competitive way, so I could drive you out of business. That's what people often do. I recognize that might actually have very detrimental effects on you personally. You might, or your father who's built up the business and might regard this very poorly or might suffer ill health as a result. None of that, as a matter of English law, following Times Travel, amounts to duress. Now, in our submission, when you take the case of a state, where one state is putting pressure on another, here actually what it is, the pressure that's really being put on Ukraine by Russia, is Russia saying to Ukraine, we don't want you to cozy up to the European Union, we want you to cozy up to us and to our customs union. Now, that isn't actually very different to what happens in a commercial context. And in our submission, just as the Court of Appeal was saying, well, and Mr. Thankey has said on previous occasions, where states enter into a commercial transaction, they should be judged by the same standards as other commercial people. Well, we agree, but the point about that is if you're going to do that, then you have to apply the rules and the approach from Times Travel. So in our submission, Times Travel is the relevant authority here, and it doesn't matter whether the threats are ones of a commercial nature or matters outside the commercial sphere, which are designed to induce somebody to enter into a commercial transaction. And the rationale that Mr. Thankey says, which is one finds in the case, is that the court doesn't want to upset ordinary commercial negotiations. But the point is, and I would suggest to your lordships, you need to be very careful here. If you accede to Ukraine's submissions, the effect of Times Travel will largely be undone. Because if in the context of states one says, well, there's some conduct which we say is not ordinary commercial dealings, and we can look at that, then when you've done it for a state, why is it not going to be appropriate in another case for a commercial party to say, well, no, this was outside of ordinary commercial dealings. This is something that is capable of being illegitimate and basically takes you back to the position prior to Times Travel. Now, we are not saying, as Mr. Thankey says, that it is necessary for the conduct to constitute a tort, the threatened conduct. But what we do say is the threatened conduct, and this is what Dimskar shows, has to be either unlawful or illegitimate. Now, you were referred, just to pick up some of the cases which I haven't addressed you on, you referred to the criminal case of Martin and the duress of circumstances defence. Now, in our submission, that has actually got nothing to do with a contractual situation. Duress of circumstances hasn't been recognised or applied in relation to a contract. And the suggestion that the authorities that Cheshire and Tritle were referring to didn't support what they were saying, we say is wrong. I referred you, for instance, to Smith and Monteith, and the whole point there was that unlawful imprisonment would be capable of being duress to person, but lawful imprisonment would not. In our submission, that entirely bears out what the authors are saying. The marriage cases, we would suggest they've got absolutely, they don't assist you whatsoever, H&H, Singh and Re Meyer. One of the points, there are 3 points we'd make very briefly. First, they concern the peculiar context of a marriage contract. As Mr. Justice Karminski said in H&H, English marriage law derives from canon law, and this has no parallel in the general law of duress applicable to commercial contracts. And secondly, although there are a couple of references in these cases to the test for duress to a marriage contract being the same as duress in the general law of contract, no one has identified any case in which the test of mere fear giving rise to duress has been applied outside of a marriage contract. And one can see that in the context of a marriage contract, the considerations are very different. And finally, as my Lord Reed says, these cases all predate the modern law in any event, and so we would suggest that they are of very little assistance. Now, my Lord, so ultimately, as I've already said to your Lordships, the question of duress, the starting point is to determine what is the correct approach in English law. If, as we suggest, the correct approach is that laid down in Times Travel, then we would suggest there is no room for the approach which one has found in the Court of Appeal's judgment, nor has Mr. Thankey been able to explain why English law somehow, simply when it's dealing with states, then applies some standard which is, he says, legitimacy of conduct by reference to international law. Why does it do that for states and not for individuals? Why, or companies, why if an English company behaves in a way that a court would regard as illegitimate, why does the court not want to look at that? But when it comes to states, an area where one would think the court would be more circumspect, does it enter into the field and decide whether the state is playing appropriately? In our submission, the court would not do that. The final point I want to make, and I see I'm over time, is just on Royal Boxalis. I'm not sure I understand what Mr. Thankey is saying about our submissions, but if your Lordships look at the written submissions we made for the purposes of this hearing at EF 44, paragraph 24, you will see that we have precisely said that Royal Boxalis is irrelevant because it is not concerned with international law questions. No international law is referred to, and I explained this morning why the point that Lord Justice Phillips made didn't assist. So, my Lord, that's all I wanted to say by way of reply.
Thank you very much, Mr. Howard. This is I think this is both a very interesting and a very difficult case. I appreciate both parties are addressing us on the basis of established authorities. It may be that we're setting foot in virgin territory in some respects here. We'll take time now to consider what's been said on both sides. We're very grateful for the very full discussion that we've benefited from, and we'll let you have our judgment in due course.